Good morning, everybody. We've got a few folks still. Oh, there we go. That was fast. We are all in from the waiting room. All right. Well, welcome to the Condominium Law Group Q&A for the week. We're happy to have you all here. I'm going to start like I usually do with some Zoom housekeeping instructions, starting with a request that you keep yourself muted unless you would like to unmute yourself to ask a question. It just cuts down on background noise and makes for a better recording after the fact. So please keep that in mind. And if anybody here happens to be new to Zoom, which I probably can stop saying this now all these years later, but your audio and video buttons are on your Zoom toolbar. That's where you can mute or unmute yourself as well as turn on or off your video. We're happy to have you here with the video off if you need to be working in the background or need privacy for any reason. And also you're always welcome, of course, to keep your video on as well. My dog will probably wander around in the background for some entertainment for those of us that are video on today. The other thing that we tell you about every week is just our disclaimer, which is that we are not here to give legal advice. It is not possible for us to give legal advice, certainly not ethical for us to give legal advice in a forum like this when we don't have an attorney-client relationship and when we don't have all the facts about your specific community, your governing documents, your governing statute, etc. So the flip side of that, or in addition to that, what that also means is that if somebody sends you one of these recordings or says, well, Lisa said blah, blah, blah during the Q&A, so you can't do this thing or you have to do that thing, you can ignore that. We're here to give general information that we think is broadly helpful and useful to community associations in Washington state, but we're not here to give legal advice or to tell you what you can and can't do specifically for your community. The chat function, which that button on your toolbar might be flashing, is the best place to ask us questions today. We're going to do another reminder / primer on the upcoming delinquency notice changes under Senate Bill 5686. And then we do have a handful of questions that were submitted in advance today, but we also probably will have time to get to a handful of questions from the chat. So please feel free to put any questions that you have today in the chat, and we'll try to get to those at the end of what we prepared in advance. And I just put a message into the chat that not only links you to our YouTube channel in case you miss one of these Q&As and you want to watch the video, but it also tells you how to submit questions for next week or any week in the future if you think of a question in the middle of the week that you would like us to answer. As I mentioned, we're going to be doing a short primer on Senate Bill 5686, and we have been doing these short primers every couple weeks or so since the end of the legislative session this year. We'll probably do one next week about the upcoming changes to the meeting statutes. So review the Q&A link, the YouTube channel link for those primers if you want to watch and learn about these upcoming legal changes that are happening. I want to remind everybody of something we announced last week, which is that we're canceling the Q&A for the first week in August, which I believe is August 6th. Chelsea, correct me if I'm wrong on that. We are going to be moving offices actually that week. And so we are canceling the Q&A so that we can be, lugging around computers and desks and getting set up in our new space, which is only about a half a mile from our existing space, but we're really excited about the move. So keep that in mind. Wednesday, August 6th, there will be no Q&A. Another upcoming date to be aware of is that CA Day is on Saturday, October 18th. We are very excited to see all of you there. If you don't know what I'm talking about, Chelsea is going to pop a link in the chat for CA Day, which is at the Washington State Convention Center, I believe, in downtown Seattle. And one of the topics that Katie, who is one of our attorneys, is going to be co-presenting on at CA Day is about the upcoming statutory changes to the meetings provisions, which are going to apply to everybody on January 1 of 2026. So we hope to see you there. If you don't know what the heck I'm talking about, click the link in the chat. And we are super big proponents and fans of WSCAI, the organization that's putting CA Day on. And so we hope some of you will consider coming to the booth and saying hi and joining us at that event. I think that's it for the announcements ahead of time. Lisa, unless, do you think I'm missing anything?
Did you mention the changes to WUCIOA, or have we beat that dead horse already?
I mean, I think we beat the dead horse, but let's do it one more time, I guess. The changes that were made to WUCIOA as it currently applies to WUCIOA communities are going to take effect later this month on July 27th. And there are provisions that are also going to apply to non-WUCIOA communities, but those don't take effect until January 1 of 2026. And the whole WUCIOA for all thing is still a 2028 start date. And we'll be talking a lot about the provisions that are going to apply to people before that in the coming months of the Q&A. So I'm going to jump in and start on a quick overview of Senate Bill 5686. And the title of this bill was something like an expansion of the foreclosure mediation program. And it does expand the foreclosure mediation program that's currently run by the Washington State Department of Commerce to include or sort of fold in community association foreclosures to that program. But what I think was sort of the more significant change introduced by this bill in terms of day-to-day operations for community associations is the requirements around delinquency notices. So I'm going to back up and remind everybody that this statute does not take effect until January 1 of 2026. A couple of months ago when we were talking about this, I misspoke and said that these changes took effect in July of this year. So if you were under the impression that these changes were going into effect this month, mea culpa, I apologize. It does not take effect until January 1 of 2026. That being said, a lot of our clients are just choosing right now to update their collections policies and procedures, their internal procedures, to comply with these requirements just to kind of work out any kinks in advance of when the statutory changes are mandatory, which is in January. Essentially, the biggest change is that it adds a delinquency notice requirement and creates penalties or consequences for failing to comply with those notice requirements. So, in the past, of course, as a practical matter, it would make sense that you have to notify somebody when their account has fallen behind, right? In order for them to know, like, oh crap, I'm behind, I got to catch up. But there was no statutory enforcement mechanism or teeth, consequences for failing to do that. The statute, as it will become effective in January, now imposes a requirement that within 30 days of an account becoming delinquent, an association has to notify the owner in writing of that delinquency. They have to include a statement that the account is past due. They have to include the delinquent amounts. They have to include a copy of the pre-foreclosure notice of delinquency. That's not a new requirement, but just make sure you put it in the packet. And the notice has to be translated into the owner's preferred language if the owner has requested that you do that. So that is probably one of the things that people are the most scared of, that seems to be freaking people out a lot, is the translation requirement. And I want to say or remind us all that this is not a requirement that you have to go out and affirmatively ask all of your owners, what language do you want your delinquency notice in? This is something that only kicks in if an owner comes back to you and says, I can't speak English very well. I don't know what this says. Can you please provide me this delinquency notice in, fill in the blank, Vietnamese, French, whatever it might be. Okay. And that's what triggers the obligation to translate the notice. This is the only notice so far that the statute, the legislature, let's say, has required an association be willing to translate. So this is not a translation requirement that applies across the board to all association communications with your owners. It's just this delinquency notice. And then the statute does require that the association has to keep copies of these notices. So this initial packet that you mail out to the owner when they fall behind on their account, number one, you have to send it both to the unit or on-site address in the community and to their off-site mailing address if it's different than that. And I want to sort of anticipate a concern that folks might have about privacy, because I've had people come up to me and say, well, what if we know they don't live in the unit and we're sending mail to them about their account at the unit anyways? What if their tenant opens it and that isn't the association violating their privacy? I think I have several comments on that, which is, number one, the tenant is probably violating federal law if they're opening mail that's not addressed to them, which is a whole different thing that we don't get into, right? Second of all, the most important thing is that the letter is addressed to the owner. The association's intent is to give notice to the owner, and what happens after that is really out of the association's hands. But third, and most importantly, probably, is the fact that you're complying with a very specific statutory requirement by mailing the notice to both places. And if you don't, you haven't complied with the statute, and all of the consequences that we'll talk about in a second will then occur for you in terms of you being limited in your collection options if you don't send the notices that are required by the statute. So you have to mail it to the unit or community address and to their offsite mailing address. You have to tell them the account is delinquent. You have to include a copy of the pre-foreclosure notice of delinquency. You have to be willing to translate it into the owner's preferred language if they request it. And you have to keep a copy of this packet that you've mailed to them. You can also send it by email, but you can't just send it by email. And that is true even for owners who have opted in to receiving electronic notice from the association. So even for owners who have opted into email notices, you have to also mail this notice to the unit address and to the offsite address if they have one. One thing I also want you to think about and make note of is that the statute requires that you mail this notice within 30 days of the account becoming delinquent. And when an account becomes delinquent might be different than what you think it is or what you assume it is. Many of our clients have grace periods and don't charge late fees until like the 10th or the 11th or the 15th of, or even the last day of the month, right? And so some people might assume that that's the date the account becomes delinquent, the date the late fee is assessed. But actually, a lot of documents specifically say that the assessments are due on the first of the month and they are late when they are not paid on the due date. So you need to have a clear understanding of when an account actually becomes delinquent, which I think for the most part is when it's not paid on the due date, then it becomes delinquent. And that's what starts the 30-day clock ticking for your obligation to send that notice. So don't start that 30-day clock ticking on the 15th, which is your late fee date. That may not actually be the delinquency date. After you send the notice that's required by the statute, you have to wait 15 days before you can take any other collections actions except for a small subset of things that I'm going to tell you that you can do. And this is the sort of enforcement mechanism or the teeth that is put into the statute. Until 15 days after you mail the notice, the only things that you can do or charge to the account are your actual mailing costs for the notice, an administrative fee of no more than $10 for sending the notice, and one late fee that is capped at either $50 or 5% of the delinquent balance or delinquent amount, whichever is less. So for the sake of round numbers, let's say that you are a community that charges dues of $500 a month. And on January 1st, there's a charge of $500 a month and it's not paid. And so on the 2nd, it's considered delinquent, right? Because it wasn't paid on the due date. That's what starts your 30-day time clock ticking to send the delinquency notice that's required by the statute. On the 15th, if that's your late fee date, you can charge a late fee, but it has to be no more than 5% of the unpaid assessment or $50, whichever is less. So what's 5% of $500? I don't like math, but actually that's not true. Math is fine. You're limited to charging, that would be $25, right? Am I doing the math right?
Yep.
So that first month, you would be limited to charging $25. And if you send the delinquency notice within the 30 days and then you wait 15 more, after that, you can go back to charging whatever your normal late fee is, and you can go back to all of your normal collections activities 15 days after you've mailed the notice. On the flip side, let's say January 1st comes and goes, somebody doesn't pay that assessment, but you forget or you decide these notices are too harsh. I'm not sending somebody a notice that says we're going to foreclose on their home because we're not going to foreclose on their home. And this is just going to create bad blood in the community and it's going to make owners really mad and I'm not sending the notice. Or Let's say that it's not even an intentional decision. Let's say you send a notice, but you forget to include a copy of the pre-foreclosure notice of delinquency, or you forget to mail it to both the unit and the offsite address, right? There's some defect in your process. You are not allowed to charge ongoing late fees. You are not allowed to charge ongoing collections costs. You are not allowed to record a lien. You are not allowed to send that account to your association attorney. You're not allowed to do any of that stuff until and unless you have mailed the notice properly that's required by the statute and waited 15 days after that. So this is the biggest thing that's going to just represent a change in practice on the day-to-day for our communities. But I think once you kind of boil it down to brass tacks, if you get a pretty simple process and timeline in place, and we're actually going to be working on a one-pager, I think, that's going to give a real clear timeline and sort of set of instructions around this. And once we have that, we'll be happy to share it with you all. Probably we'll have it at the booth at CA Day for those of you that might be there. Once everybody just has a clear understanding of what's required and how to make it happen and how the timeline should work, I think practice is just going to make this sort of like 2 years from now, we're going to be like, oh yeah, that's easy. It's a nothing burger. We've been doing it for 2 years. It's fine. It just feels like a really big change right now. There were other things that happened as a result of Senate Bill 5686, including requirements to participate in a meet and confer with the unit owner, and possibly also being referred to mediation by a housing counselor if the owner contacts one. And there are limitations on what you can do during both of those processes. So if you are asked to participate in a meet and confer, or if you are referred to mediation with an owner as a result of them contacting a housing counselor, you cannot assess legal fees incurred during that process to the delinquent account. Those legal fees have to be treated as a common expense. So that's a change, right? Previously, the statutes and the governing documents for most communities authorized an association to assess all of its reasonable attorney's fees and costs incurred in collecting unpaid assessments to the delinquent account. Now, if you are incurring those fees while you're waiting for the meet and confer date or waiting for the mediation date, or if you incur them because you're asking your attorney to advise you during the meet and confer or during the mediation, you're allowed to do that. You just cannot assess those costs to the delinquent owner. There are other things too. And I did notice actually when I was looking at the schedule for CA Day that there is going to be a whole class on Senate Bill 5686 and the practical impact it's going to have for community associations. So I think that's probably good enough for now, Lisa. If you have anything you think that I should also highlight or that you want to add, feel free, and then we can jump into the rest of the questions.
I think just really quickly, you pointed out that the notice of delinquency is not a new requirement, but excuse me, a new requirement, but I did want to point out that they did change some of the language in the notice of delinquency. And that's just a reminder generally to make sure you're just keeping up on what is required to be in that notice. If you have questions about it, certainly you look at the statute or talk to your association counsel. And there is an obligation to make sure that it's updated with the correct phone numbers and websites for the contacts for an owner.
Yeah. And Lisa, you check like at least once a quarter, I think, for us to make sure that our forms are always updated. And
That's
I know
correct.
Lisa just sent out an email to the collections group in our office yesterday because one of the websites had changed a little bit. And so all of our templates have to change. So I would say on average, it changes at least twice a year, at least. Wouldn't you say, Lisa? The phone
It
number or
seems like
email
it.
address or whatever.
Yeah, I think the Department of Commerce is kind of moving things around, and in particularly since the HAF program is ending, I think some
Yeah.
things are changing. But if you have the right, the basic right place where it's, you get to the right company or right place, I think you're probably fine. But do try to make sure you don't have dead URLs and things like that.
Yeah.
So check them.
Okay. And then Lisa, before you jump into the question, I'm just going to remind everybody, if you have questions you want us to answer, now would be a good time to put them in the chat so we can get to them when we're done with these questions.
All right. First question. If a board member has a strongly dissenting opinion, but the majority of the board adopts a decision, should the dissenting board member be encouraged or discouraged from speaking to members of the association in protest against the board's decision? I, my initial response is this is a pretty specific question. It sounds like there might be some stuff going on with your board that or your community that may be of concern. So make sure you know what the options are if a board member is doing something that the community doesn't like. That there are methods to remove a board member. We've talked about that extensively in the past. But I will say that a dissenting board member should respect the democratic process that the board has made by which the board has made a decision. So if the board votes and the majority rules and the decision is made and somebody's unhappy, they should support the decision of the board. That's sort of how this all works. Um, we have to acknowledge that our climate now is different than it was even 5 years ago, and there's a lot of dispute and a lot of animosity, and so things do come up, and there might be angry folks. There isn't a legal remedy really necessarily to stop somebody from saying what they want to say. I mean, we all kind of live by that rule, right? You have your your right to speak. Um, but generally speaking, the board should be speaking with one voice. Board members should not be going behind the rest of the board's back and bad mouthing decisions that were made. It doesn't look great. It might be something that you want to have in your community, some kind of a civility pledge, at the beginning of each meeting that you all agree that you're going to be civil and you're going to, I think there are lots of examples of this on CAI, and you might ask your community association council if they have ideas for that. Um, and also remember that board members, when they're not at a board meeting, are owners. And owners get to say, I guess, what they want about the community. Again, it's not the greatest look, so you may want to have that conversation, but a board member is just an owner. They're only working as a board member when they're sitting at that table at the board meeting. So, remember that. Um, you might want to remind your board or look to the statutes to see if they help you in guiding what the responsibilities and priorities are for each board. If you look at RCW 649410, it talks about that members must exercise the degree of care and loyalty to an association that an officer or director of a corporation would. There are standards of care and loyalty to an associate or to the association by a board member that are written into the statute. So if you're having a real issue with this, certainly talk to your association counsel about whether or not there is a true legal issue that may be confronting you. But it sounds like it may just be you kind of have some disgruntled folks who kind of grumble. And if that's the case, I don't have a great response for you, except that just maybe a reminder that things need to be civil and that the board, once it makes a decision, the decision has been made. And it was a majority. Anything to add to that, Valerie?
The only thing I can think of is that some of our clients do adopt a board member code of conduct.
Yeah.
And we actually write that right into our bylaws when we're doing restatements for our clients. The question, of course, becomes one of how you enforce that if a board member violates it. Because, are you going to fine them? Is that going to be effective? It's kind of complicated and annoying to remove someone entirely from the board. And also, I think that respectful dissent is actually something that should be welcomed and encouraged. And I think Ken and I used to do the Q&A together every week for a lot of years. And one of the things that I actually really loved is that occasionally a question would come up and Ken and I would have really different perspectives on how to answer that question. And I think Ken and I were both benefited by that difference of opinion, but I also think that everybody who attended the Q&A got to benefit from that difference of opinion. Reasonable minds can disagree on certain things, and so I think there's a really big difference between reasonable dissent and between somebody walking around behind the back of the board bad mouthing them and just being pissy because they didn't get their way, right? But again, it goes back to like, how do you enforce that and how egregious is the behavior? And does it rise to the level where you want to do something like call an ownership meeting to kick somebody off the board? So your mileage may vary as to which of these options is your best one, but I think that covers it.
Okay. Next question. It's sort of a statement less than a question, but we'll try to do our best to answer it. It's asking for guidance on handling cars that are parking on the property with expired tabs and the car may be full of garbage. I think generally speaking, this question is way too specific for me to know how to answer, and I have not enough information to fully answer the question, but we can kind of give you some places to look to see whether or not you have a resolution or a way to resolve this problem if it is affecting your community. Look at your governing documents, I guess is number one. Do you have rules? Do they give you clear guidelines about parking, about the condition of vehicles? Do they require that vehicles be fully licensed and have current tabs? And if that is true, does your community have the ability to regulate that? Do you have a fine policy, a compliance policy, with the appropriate due process? Notices where you put a tag on the thing or send the owner a letter explaining that their car is improperly parked or has expired tabs. If that is something that is a rule, appropriate rule in your community. But there's so many factors here, and I don't have any information about what your community is, or if this is a public street, if this is a, a road in your place, if it's parked in the carport, if it's parked in somebody's driveway. So I think you really are going to want to talk to your association council about what your rules say, whether you need to amend those rules, and what is going on specifically in your community, and whether or not your association has the right to even regulate that kind of activity or behavior. It might be a municipal issue. I have no idea if it's actually something that your association can control or can uh, issue compliance fines and notices for. Um, you know, the other thing we often talk about in these things is sometimes it just ask, if a car is bugging you and it's parked in front of your house or parked improperly, maybe just saying to the owner, hey, your car is kind of bumming me out, or it's in the wrong place, or it's affecting my life in some way. Sometimes neighbors, despite what we talked about before, being this being kind of an animus community situation right now, they might be perfectly willing to move their car or to do something or explain what's going on. Maybe there's something that's happening in their life that is affecting that you can give them a little bit of grace about. But I think the main response is, I don't know because I don't have all your information, but this is, some places you can look. And if you have specific stuff, certainly reach out to your association council to help you with your rules if necessary. Anything to add to that, Valerie?
No, I think I'll jump into the next question, which is also parking related, and it reads, guest parking. We have a few owners who use it because there are not enough spaces allocated to their unit. Tracking it is hard. Are we able to send a warning letter with a potential fine rather than just calling the tow company? And do you have any guidance? So I think, to piggyback on what Lisa started saying, the first thing I would tell a client that was coming to me with a question like this is that you need to make sure that you have really clear rules and procedures before you take any enforcement action. But it sounds to me like I'm reading between the lines and you're saying there's not enough spaces allocated to the unit. So it sounds to me like this might be a scenario where each unit is assigned, one or two parking spots, but there might be 3 or 4 cars in a given unit, and that you've got a certain amount of guest parking that's available to people within the community. But that's, certain owners maybe are sort of accessing that and maybe abusing the privilege of the guest parking more so than others. If the guest parking, assuming that this is limited common elements, the association certainly has the authority to regulate the use of those parking spots. But I do think that it makes sense to have specific and clear rules about how the spots can be used. And as an example, I think Lisa was talking about having seen something recently on the CAI message boards about comprehensive rules that associations have with like tags that are assigned to the units. So management or the board can actually monitor who has which car and where it's supposed to be parked. They also, one thing that you would want to have is clear rules about how and when the guest parking can be used by unit owners. So maybe you're fine with unit owners using the guest parking, but a car can't be parked continuously in the guest parking spots for longer than 48 hours, or maybe it's a week. Every community is different in terms of what it wants and is willing to tolerate when it comes to use of guest parking. You also want to make sure that your fine policy or enforcement policy, whatever your rules, if that's where it is, has a really clear description of what will happen when people violate the parking rules. And to your question of whether you can send a warning letter with a fine rather than calling the tow company, the answer to that question is almost always absolutely. As long as you have all of the authority correct in your documents and you follow both your documents and the statutory requirement to give a due process notification. you absolutely have the right to take a less aggressive enforcement action as opposed to immediately jumping to impounding a car for being parked in the guest parking spots. We would always recommend warning letters or tagging the car or some other attempt to warn an owner before you tow the car. And I'll note that it is not uncommon for an association to be dragged into tow court when an owner challenges the association's authority to impound their vehicle after that's been done. And so there's more risk to the association in towing a car than there is in fining a unit owner. So I think for sure, I mean, our approach to compliance issues, regardless of the nature of the compliance issue, is always to start with the most cooperative, least aggressive option first. Start by asking for compliance, engaging in communication, as Lisa mentioned earlier, to understand what might be going on in that owner's life that's contributing to the violation. And only if that effort fails do you then go to like sending your warning letter, sending the fine notice. And only if that fails do you then consider more aggressive compliance options like impounding somebody's vehicle. One thing I will also offer is that Washington State has very specific administrative rules about what you have to do in order for an impound to be proper, including you have to have certain types of signs posted at the ingress and egress of the parking area where you would be enforcing this and potentially impounding cars. So you want to make sure that you have a clear understanding of what rules you have to follow in order that if you do tow an owner's car, that you've dotted your I's and crossed your T's. Because procedure is hands down over substance. Procedure is the biggest way that our clients mess up and the biggest sort of mistake that leads to successful owner challenge of association actions. Lisa, did you have anything you wanted to add on that one?
Nope, I'll just go to the next question. Next question. I was curious if you had any details on the possible early adoption benefits of the Clean Building Performance Act, including deadlines for enrollment, qualification, and promoted benefits to associations for opting in early. I was just going to put in the link oh, there we go. The short answer is this isn't really our area. We don't specifically operate in this space, but I did just put a link. As one of our old paralegals used to say, to the Google. I just basically put in your question, and the Washington Commerce Department's website came up with information on early adopter incentives. I just put that link in the chat. Ken reported that one of our clients has looked into this process and reported they can get something like a 30% rebate for the cost of having the analysis done early on their building through a grant program until the money that's available runs out. We haven't been involved in any of these, but certainly, take a look at the website and, talk to your specific counsel or professional who may be able to assist you with this questions in the future if you have more questions about it. Anything to add to that, Valerie?
Nope.
Okay, I'll go to the next question then. Next question. We are a non-WUCIOA HOA with CC&Rs dating back to 1991. Are we required to send monthly meeting agendas and minutes to owners by email only if they have opted in? Our portal has an opt-in feature for general communication preferences with email and paper as the choices. Many owners never look at the portal, but 66 out of 77 have email and use it regularly. 1 or 2 have sent a message saying they want the minutes mailed, but that's it. So what's our obligation? Would we have to amend our documents to send agendas and minutes by email? There are a lot of kind of specific questions wrapped up in here, but I can speak generally to electronic notice and also what things are required to be sent to owners specifically right now. Some documents aren't required to be sent to owners at all. I mean, certainly if an owner asks you for an association record, we've had lots of conversations about that. Those would be things you want to send to them. So meeting minutes are one of those things. You don't have to send them out to everyone. You do have to keep them and you have to make them available to an owner if they ask you for them, but they don't have to be mailed out every month or emailed out every month to an owner. If your association has open meetings requirements currently, then certainly the agenda would be something you would want or would need to send out to owners either on a monthly or annual basis, alerting them of the time and date of the meeting. And that could be sent, as you say, if someone had opted into electronic notice, you could be sending it that way to those folks. If they didn't, then it would be sent by mail or whatever other notice is required for that particular thing. As Valerie and I were talking about before, excuse me, keep in mind that everyone's going to be doing open meetings soon. So that question about sending out meeting agendas and meeting notices is going to be for everybody in the next in January. So make sure that you're aware of that requirement that if you are holding board meetings, everyone's going to need to start sending those notices out to all your owners, whether again, it's an annual, every first Monday of the month, we have a board meeting and everybody knows that's when it is. Or if you're changing it every month or every quarter, sending out notice to your owners. I did just want to kind of remind everybody, we talked a long time ago about this electronic notice thing. It's a statutory require or statutory authorization. You don't need to amend your governing documents to approve sending things by electronic notice to owners, but you do have to make sure that an owner has specifically opted in to receiving notices by email. So if an owner has not said to you and you don't have something like a checkbox form that says, yep, please send me stuff by email, then you need to be sending those things by mail or I guess personal, hand it to them if that is what you're required to do. So make sure that you have it's called a tangible medium. So do you have something that was specifically authorizing you to send things by email? Make sure you're following those requirements. If you want to check back to our previous conversations, it kind of discusses about what happens if you get a bounce back on an email and all that sort of stuff, or if an owner revokes that consent. Um, and then there are certain things that have to be sent by mail. See Valerie's previous comments about the notices of delinquency. Some things, yeah, sure, you can send it to them by email as a courtesy, but it actually has to be physically mailed as well. So make sure that if there are certain things, we've talked previously, I think we like the idea of compliance fines being, an actual hard document being sent. It's not required, but there are certain things that you may want to send also by mail, even if someone has opted in um, to email communicate or electronic communication. And this is not just WUCIOA communities. And you mentioned your pre-WUCIOA community. This is everybody. This is everybody right now. And this is sort of a function of it happened during all the COVID stuff when everything was sort of changing at that point. So the legislature acknowledged that a lot of owners just communicate or just read their emails and don't read their their mail anymore. So just make sure you're paying attention to whether or not somebody has specifically consented to you to have electronic notice. And again, if there's formal meeting or formal notice required, so there's something specific happening, like the budget. We're talking about sending out notices of the annual budget to people that's going to be coming up soon. That is something that you probably are going to have to mail to owners and not just email to them. And again, we talked about fines, delinquency, and that kind of new rules, things like that. So just make sure if you have specific questions about whether or not you need to mail or can email something, you can ask your association counsel, but just know that you have to have a specific consent from an owner to do so. For the things you were talking about, meeting minutes and agendas. And again, you don't have to send those out unless you're required by law to do so. And a lot of those will be coming up soon as far as meetings. Anything I missed, Valerie? There's
Yeah, I mean, what I will say, a couple of things. Because the question specifically asks about agendas and meeting minutes, I want to say that it is true that you're not required to send meeting minutes to your owners, that you're only required to give them a copy if they ask. However, there is a statutory provision, and it currently only applies to WUCIOA communities, but come January, it's going to apply to everybody. And it says that an action seeking relief for failure of the board to comply with this section may not be brought more than 90 days after the minutes of the board meeting at which the action was taken are approved, or the record of that action is distributed to the unit owners, whichever is later. So here's the translation. If your board makes a decision, but it somehow messes up its procedure and the decision is challenged by a unit owner, they have 90 days after receiving notice of that decision via a copy of the minutes in which to challenge that decision. And after that decision, the decision is going to be deemed valid, even if it would have been deemed invalid had it been challenged in time. So some communities might want to consider affirmatively mailing out a copy of the minutes once they're approved every month or every quarter or whatever on some sort of schedule that you determine is reasonable, because that is what triggers or starts the 90-day clock ticking on an owner's ability to challenge the board's action. I do not want to see any community trying to abuse this provision by saying, well, procedure doesn't matter because of this 90-day safe harbor thing. As long as we mail the minutes, we'll be fine. Because I think that is not what the legislature was intending to protect here. And I think that kind of approach would end up blowing up in your face if it ever ended up in front of a judge. But it is one thing you could consider when deciding whether to affirmatively mail out the minutes to everybody, even though there's no statutory requirement for you to do so, because it triggers that 90-day clock ticking. As for the follow-up question in the chat, simply giving your board or your manager your email address is not opting into receiving electronic notice. I don't think it has to take a specific form. Some of our clients did and do send out like opt-in forms and ask owners to like check a box and put your email address here and mail it back to us, and that's fine. I also think it would be perfectly fine if a unit owner emails a board member or the manager and says, this is my email address and I would like to receive all association notices by email. That's perfectly fine as an opt-in, because you can save a copy of that email as a PDF and stick it in the association's records, which creates tangible proof of the owner's decision to opt in. Simply giving someone your email address is not opting in. I'm going to jump to the next question, Lisa, unless you have anything else.
Go for it.
Okay. At an HOA meeting, when does the board vote and when does the community vote? I know the full community votes to ratify a budget and accept revisions to governing documents. We will award several contracts at an upcoming meeting, like deck painting, parking lot resurfacing, etc. We will also be asking for a special assessment to cover those expenses. Which of these issues does the board vote on and which does the ownership vote on? And there's other examples, but I think we understand the question here. And I think what I want to start by saying is that if you're talking about an association-wide meeting, generally the only votes that take place at those meetings are votes of the ownership as a whole. Board votes and decisions take place at board meetings. So in the specific example of a community that's got some big projects coming up and they both need to award contracts, but also adopt a special assessment to pay for those contracts, the way this would work is that the board at its meetings would solicit bids from potential contractors, would look through those bids, determine which estimate was the best one for the association. The board would vote at a board meeting to award the contract to one contractor or to another contractor. And then the board would also adopt a proposed special assessment budget, mail the ratification packet out to the ownership, and then have a budget ratification meeting at which the ownership votes whether to ratify that special assessment. If we're talking about like an annual meeting, an association meeting, the types of votes that take place at those meetings are usually things like electing board members. Are we going to adopt this proposed amendment to our declaration? There are other association-wide votes that are appropriate to take place at an HOA meeting, including things like waiving audits if it's allowed by the statute for your community. There are community votes to transfer funds to reserves to comply with certain IRS codes. Like I said before, electing directors, amending the governing documents. Those are the types of votes that the community as a whole votes on. The community as a whole does not vote on who to give the contract to for resurfacing the asphalt parking lot, or re-upping a contract for cable or broadband or trash collection or whatever. The board is the entity that is charged with and given the authority to make all of the day-to-day business decisions for the association. That's what you elect them for. The ownership elects the board, so the board is empowered to award contracts, re-up with the landscaping company, propose a special assessment budget to the ownership, etc. So I think that covers the question and sort of clarifies the difference here between what are the board decisions made at board meetings and community decisions made at association meetings. But if you want to ask for additional clarification in the chat, you're welcome to do that, and And Lisa, if you have anything to add to that, feel free to let me know.
Nope, I think that covered it from my perspective. I'll go to the next question. My question is about annual audits. Currently, are all COAs/HOAs with an annual budget greater than 50,000 required to have an annual audit? We're a COA organized under RCW 6434, and we've had the option to forego the annual audit if the majority of the owners approve to waive that year's audit. Going forward under WUCIOA, do I have it correct that no association with an annual budget greater than 50,000 will have any method to forego the annual audit? If that's the case, did the legislature ever discuss the effective inflation on the budget total? I won't get into it now how wasteful $2,500 is to a small association. The short answer to your question is yes, a lot more or many more small condo associations will be required to have audits in the future under WCIOA. Currently, an association organized as the question presents under 6434 372, it says at least annually the association shall prepare an audit. The financial statements of condominiums consisting of 50 or more units shall be audited. So that the 6434 discusses the number of units, not the amount of money, just to keep that in mind. An audit is required. However, an association may waive annually by their unit owners, of which 60% of the votes are allocated. So it's not a majority, it's 60%. Just keep that in mind for you currently under 6434. Under WCIOA, which is effective for those communities in January, for all communities in January 1st, 2028, the change says if annual assessments of $50,000 or more, then it must be audited annually. And that may be waived annually by unit owners other than the declarant of units to which a majority of the votes of the association are allocated. So, yes, that will change in January of 2028. Currently, your guard line is the number of units you have, and it's a 60% vote on whether you can waive that audit. In the future, it will be $50,000, as you stated in your question, and it's a majority of the owners. And again, it's an annual vote to waive the audit. So that is something that needs to come up and be in the annual meeting minutes of the association so that everybody knows what's going on. And that language that is currently in WCIOA, in the new WCIOA, doesn't change any edits to the WCIOA bill. It just changes the way that 50,000 is written. It's currently written out by FIFTY, and it will be in the dollar amount, $50,000. If you are questioning whether you're as a 6438 community or whatever other community you're organized under, you can just, as I said, go to Google or to whatever your favorite search engine is and just type your 6430 whatever and audit, and your section will come up if you have any questions about that. Anything to add to Valerie?
Nope, I think you covered it. So I'll jump to our next question, which is, if there's a unit that either did not apply for an architectural review authorization or deviated from the process and was not dealt with by the board at the time, can the current board take action against the resident for non-compliance, or is there a limit to the amount of time that a board has to act? And I think, sorry to be a lawyer, but this is just way too specific, and also there's not enough information, both at the same time. So you need to submit this question to the association attorney for the community where you are dealing with this issue. But I can certainly talk about like the factors and the variables that we would need to look at in order to answer this question. But I also want to caveat that based on the answers to these questions and the specific issues that you're dealing with, the answer could be completely opposite, just depending on the specifics, right? So there's factors that would affect the current board's ability to enforce. One would be the passage of time. So there's probably at a maximum a 6-year statute of limitations, but it could be 3 years, and it depends probably on the issue in the community. And so depending on how much time has passed, the board might be completely out of luck in its ability to retroactively enforce against the property. I would also want to know whether the person who owns the property now is the same person who made the decision to violate the ARC process, because if the property has been sold between the violation and now, and there was no disclosure at the time the property was sold, like it wasn't included on the resale certificate or anything like that, I think your ability to enforce now is weakened. Um, I would also need to know what's the violation we're talking about. Are there other similar violations, or has the covenant or restriction been effectively abandoned by non-enforcement over a longer period of time? I would also want to know how obvious or noticeable the violation is. What's the impact on the community? Are there any city or county codes that are being violated? Whether the change was actually even within the board's discretion to approve during that time. So for example, setbacks from property lines. The board doesn't have the ability to approve a structure that violates code requirements for setbacks. And other things might be mandated by the CC&Rs directly, and the board has no discretion to offer a variance. So I think there's just way too much that we don't know. And also, if you told us all the answers to all these questions, it would be too specific and we'd be giving you legal advice. But hopefully, at least knowing that gives you some information about the questions that the association attorney is going to ask when trying to determine whether this is something that the board currently has the authority to take action on. The other question that I would ask is, what's the impact on the community, and what's the general approach to compliance within the community? If we're talking about a minor issue that's not a code violation, there's very little impact on the community. It's not something that's, an eyesore or very visible to a lot of the folks that drive through community or whatever. At a certain point, I do think, HOAs sometimes get a bad rap for, like, there's this perception that there are board members going around the community with a ruler measuring people's lawns, right? And that perception is perpetuated by occasionally some communities fixate on things that owners perceive as relatively minor. And one of the questions, or sort of, I guess, overarching issues for me is your board governing with respect to ARC issues in a manner that's consistent with the overall ethos of the community as a whole, right? But assuming that it's a more major issue, that it's an eyesore, that there's a nuisance, that there's, that it creates a problem within the community, there might be an ability to enforce depending on the answers to some of the questions that I went over earlier in my answer. So Lisa, I don't know if you want to add anything to that. If not, I have a couple of things I want to cover before we are done today.
Nope, go for it.
Okay, so this just popped into my mind because I had an email interaction earlier this week, or maybe last week, whatever, where a collection file was sent to our office, and there were a bunch of fines on the ledger, and the letters that were sent to the unit owner about the fines did not contain proper due process notifications. And the surprising part for me was that I got an email back from the management company saying, are you saying we have to give due process in every notice? And it was sort of a surprise to them. And it was a surprise to me that it was a surprise to them, because this is not a new requirement. And there was even some indication in the email exchange that maybe there are law firms out there that are giving different advice than we are on this, but I don't know any of our compatriot law firms in this practice area that would advise differently than this, which is, by statute, under Washington state law, an association only has the authority to assess a fine against an owner for violating the governing documents if a certain set of prerequisites are met. One is you have to have a fine policy or a schedule of fines that's adopted by the board and published to the owners, so that owners know exactly what they're going to get fined if they violate the rules. And the next one is that you have to send them a notice of the violation and the proposed fine, but the letter has to tell them they have the right to request a hearing before the fine is assessed. Due process, by its nature, happens before the penalty is incurred, okay? So what the letters said was, you violated this provision of the documents. A fine of $500 has been assessed. It was also a very large fine, which is a separate issue. And then later in the letter, there was something buried that said something like, if you request a hearing, the fine won't be levied until after the hearing takes place. But nowhere in the letter did it actually say, you have the right to request a hearing before the fine is assessed. And also sending a letter telling somebody they're being fined $500 or $50 or whatever it is, and then later saying, you have the right to appeal this fine, or you have the right to request a hearing, but the fine has already been assessed. That is not due process, because if the fine is assessed before they've been notified of their right to request a hearing, that's not due process. That's just an appeal. That's an after the fact thing. And frankly, there's no requirement under Washington state law to allow owners to appeal a decision that's already been made by the board, where there is a statutory requirement to notify owners of their right to due process before you can assess an enforceable fine. So I thought it was worth mentioning again here, just because this is something we deal with over and over and over and over again in the context of collections files that come to us, sometimes with hundreds and even thousands of dollars of fines on the ledger. And then we end up with really unhappy clients when we go back to them and say, sorry, we can't collect these fines because your procedure is not compliant with Washington state law. So at the risk of, beating the same dead horse, not a different dead horse than the one we were referring, we need to figure out a better, less violent.
Realize as soon as I said it, yeah.
At the risk of sounding ultra repetitive, and I know a lot of you who come every week, this is like no news to you. And so if you need to leave early, then feel free and Godspeed. But the way that you assess fines that are actually enforceable and collectible is you have a fine schedule or a schedule of fines that tells owners exactly what happens when there are violations of the governing documents. So first violation, warning; second violation, $50 fine; third violation, $100 fine; continuing violations, $50 a day or $25 a day or whatever the thing is. So you have to have one of those that's adopted by the board and published to the ownership. Then if there's a violation of the governing documents, your notice of violation to the owner has to say, this is the fine that would be assessed for this violation. You have a right to request a hearing before the fine is assessed. To request a hearing, submit it in writing to the manager at this email address or whatever. If you do not request a hearing, this fine will be assessed on X date. You can give them a time limit that you don't have to just leave it open-ended. You can say, to request a hearing, you have to respond in writing within 10 days. And only after the period of time during which they have the right to request a hearing has passed, should you then assess the fine on your ledger. And I know that it just creates an extra administrative step, and that's a pain in the keister. And so I do want to acknowledge that, because especially if you're a manager dealing with, 8 associations and 100 people at each of those associations, even if there's only 1 or 2 violations per community per month, it's just a headache. It's a headache. And I want to acknowledge that, but it is what is required by statute. And so, so keep that in mind. And then somebody asked if we have a fine template on our website. We do not. We do draft a fine and enforcement policy for our clients for a flat fee of $4.95, I think. And it includes templates for warning letters, for violation notices, for owners to report violations to the association. It includes a template letter for telling an owner after a hearing what the board's decision is. So it includes all kinds of templates, but we don't have those for free on our website. But it doesn't have to be anything fancy. Your letter can literally say, we're writing to you because your garbage cans have been left out in your driveway for 2 weeks. This is the section of the rules that you're violating. Under the fine policy, this violation would carry a $50 fine. You have the right to request a hearing before we fine you for this violation. If you want to do that, here's how, and here's the amount of time you have to do it in. If you don't request a hearing, this fine of $50 is going to be assessed on X date. It does not have to be formal. It does not have to be there's no specific format that's prescribed by the statute, as long as you're communicating clearly and telling them they have the right to request a hearing before the fine is assessed. And then lastly, there's a question about which session was the primer on Senate Bill 5686. You plan to go back and view it on the YouTube channel. Was it May 21st? I don't remember, but we did it today, just go back to once the video is posted for today. If you start the very beginning of the video, the first maybe 10 minutes after the announcements was going over in pretty great detail Senate Bill 5686.
And if you need to search for anything, if you just go to the YouTube channel, go into that actual channel, there's a little magnifying glass, you type SB, whatever next to it, whatever word you're searching, and it will bring up all of the ones, and then you can expand them and see if it was in fact discussed the way you want it to be in that session.
Yes. And if all else fails, you can send an email to info@condolaw.net and ask for what date it was that we did the last primer, but we did it today. So hopefully that will answer your question. And it's 11 o'clock, so we are perfectly out of time. Thank you all for joining us today, and we will see you back here next week. Bye, everybody.
Thank you. Bye.